Welcome, everybody, to the Velocity Real Estate Podcast. Special thanks to our sponsoring broker, Keller Williams Preferred Realty in Orland Park. We have a special guest today. This is Joe Hill. He's our real estate attorney. Many of you don't know, but in Illinois, it's highly advisable that a real estate attorney oversees the deal from the time the contract is signed until the deal is closed. There's a lot of documents to sign, a lot of things that need explaining. So once Yvette and I identify a property for a buyer and we negotiate successfully to price and terms and the contract is signed by everybody, then we hand the contract off to Joe Hill. So Joe, tell us a little bit about yourself and maybe we can discuss some of the things that you come across once the contract's been forwarded over to you.
Okay, my name is Joe Hill. I'm an attorney. I've been practicing for approximately 27 years. I handle a fair amount of both residential and commercial real estate transactions, in addition to typical business purchases and sales, some estate planning, other leasing, zoning, and general practice transactional type matters. Frank and Yvette asked me to come here today to talk about certain issues that I come across in real estate transactions. The first part of this podcast is after when I receive a contract, what issues do I see that could typically be avoided or discussed with your client pre-contract? Later podcasts we'll talk about contract issues, financing, due diligence, and inspection type issues and post-closing matters. But for the purposes of this podcast, we'll just go over a few issues that I've encountered in my practice that I think could have been avoided by competent and able realtors before I even get a contract.
Joe, are you saying we're competent and able realtors? Is that what you're saying?
Well, I can tell you this, that just like attorneys, I come across thousands of attorneys in my career, and there's a certain group of attorneys that are adversarial. There's a certain amount of attorneys that are collaborative, and generally the local attorneys that I deal with all the time are people that I could talk on the phone and work out issues. Then there's another group of attorneys that are somewhat radio silent and are very difficult to reach. And you probably come across the same type of realtors in your line of work as well.
Oh yeah, well we'll light them up. Well, I'll do it, so you don't have to get in trouble. But so go ahead, Joe, share some stories with us.
Yeah. So the reason I'm here is I generally don't have these issues with Frank and Yvette. They are very competent realtors. That said, they asked me to come here and just talk about a few instances where I feel that maybe certain things could have been avoided before. Especially on the purchase side, before our clients pay for an inspection, pay for an appraisal, and go down the process, and also are involving a seller where they could have otherwise sold a property to somebody else. And in one instance that I can recall, a potential buyer had a business that they were going to somewhat operate out of their house, and they had a work truck. And the problem with the work truck that can't fit in a garage is neighbors often complain of a work truck being on the driveway, which is not permitted in many jurisdictions. So that's something where somebody goes through the process, signs a contract, has an inspection, and may find out either before closing or even after closing, and it becomes a problem. Now they have to find a place for their truck. Is this something, Frank, that you've encountered in your career where a client had an issue with their business practice at a house?
Yeah, we actually have had this happen before. The smart clients know, hey, I have a work truck or work trucks. Is that going to be allowed? Have you had that as well, Yvette?
Oh, yeah, I had it a couple of times, especially where there's homeowners associations. That's where you usually have more trouble with the work trucks being parked in the driveway.
Yeah, and then sometimes, Joe, like signage. So people want to have signage for their business on their home. That's kind of a similar thing, right?
Exactly. Generally, in unincorporated areas, it's a little more lax with that type of stuff, even though in many counties it's still not permitted in residential areas. But the bigger lots, the bigger area, if you have on a 5-acre lot, people may be less combative with something like that as opposed to having a work truck in your driveway in Hinsdale may be more of a problem.
Excellent. I've had a few instances with you, Joe, where we had a signed contract, and when I send the contract over to you, you do some due diligence. You check the PIN number. What are some of the things that you do when you first get a contract?
Well, the first thing I do is talk to the client and get an impression of where they've been and where they want to go. And also, I do look at property taxes, especially over the last 6 or 7 years, with increased assessments and a variety of homeowners exemptions, senior freeze exemptions, which will affect the tax bill going forward if those exemptions don't apply, and then our clients are stuck with a higher than expected tax bill.
I remember at least one instance with one of our contracts we sent to you that the seller was like in default of paying their taxes. Do you remember that? Where they were either behind or they hadn't paid the current tax bill and they should have?
I've seen that. That's actually very, very common, especially in a time of a sale, especially if it's a distress sale that taxes aren't paid. But generally, to close, a seller has to be current with their taxes. The main issue here, though, to really be aware of is to make sure that the seller has funds to pay for everything. This was more of an issue during the 08 to 2012 timeframe where people may have been underwater on their mortgage and then haven't paid taxes, and then there isn't enough equity in the house to pay for realtor commissions and tax credits and so forth.
Interesting. Yvette, anything to add to this?
What I remember, I had a client of mine. They put an offer on something. More like I had another agent that was asking me about a property because they put an offer on something and they never checked. I always check the taxes, the tax records, because most times the other agents, the listing agents, don't check the tax records and they have the wrong taxes in there. They either have they don't have the senior exemption listed in there. They don't have the senior freeze in there. And they go with it, thinking that the clients can afford to purchase that house. And when everything is done, most times they do the inspection. And then when it gets to the lender, and this is something like pre-contract, something that the buyer's agent has to check on those taxes before they submit the offer, especially if it's clients that are like very tight with the monthly payment. Anything that changes with the taxes can make it, a deal breaker because they can't afford the house anymore.
That happens two to five times a year
Mm-hmm.
on deals of mine where the taxes are $200 to $400 a month more than what they expected. You're totally right. A couple other items, the pre-contract, maybe that could have been discussed with the realtors prior to purchasing the house. I had a client who really wanted to build a pool. The problem with the pool, you have to talk to the village and make sure homeowners association decide whether it's even permitted, whether or not the village will permit a pool to be constructed in the backyard. There's certain floor area space requirements, pool requirements, what kind of security, do you need a fence? There's a variety of issues with having a pool, let alone insurance. It's not as simple as just calling a contractor and putting a pool in. So oftentimes clients who are wanting to put in a pool may be disappointed in the process and cost and timeline of putting in a pool.
All right. So another thing that just popped into my head that's interesting and gets complex sometimes is who owns the property. So a lot of times we have property where the seller is deceased and they've set up a trust. Sometimes the trustees have changed in the history of the ownership of the house, and nobody knows like who the real owner of the house is. So Yvette and I, we take a listing based on what the family tells us. The owner is, John Smith, the executor for the Smith Family Trust. But then when the contract gets signed and we have a buyer, then Joe Hill will go ahead and check the real ownership and walk us through some of those things.
Well, unfortunately, it's a little later than that. If I'm representing a buyer, I won't know who the actual record owner is until I receive a title commitment from the seller. In those cases, the name of the vesting owner or the seller would have to match the contract. Uh, it's not that uncommon where there is a mistake. In that case, we'd have to prepare an amendment and change the contract seller to the correct seller.
What about the seller, Joe, when you're representing the seller? Like, what do you require to untangle like the true ownership of the house?
Well, if the contract is signed improperly, that will have to be fixed, whether it's as representing a buyer or a seller. It will have to be done by amendment, and the amendment will have to be provided to the lender. If there's a case where there's a dispute with family members, that could be an issue, frankly.
Now, what happens when the people who own the house, they put the house in trust, and when they're deceased and the house goes for sale, and in the trust it says the house is equally divided amongst my 5 children. They're all like equal partners as trustees. Like, does everybody need to sign the contract?
With a land trust, it's a little different. There's two types of trust. There's a revocable living trust for our purposes here. A revocable living trust where the trust document itself will list the initial trustees, and then there'll be a laundry list of successor trustees. With a land trust, the land trust itself is the trustee, and it'll name the beneficiaries, contingent beneficiaries, and it'll note who is holding the power of direction. So that the actual trustee of a land trust would be, for instance, like Chicago Title, holding as the trustee.
Mhm.
If let's say a mother and father were the primary beneficiaries of this land trust, and let's say the mother and father hold the power of direction, once the mother and father are deceased, the land trust will ask the contingent beneficiaries to ratify the terms of the trust. And also, if there's, let's say, 10 beneficiaries, one of those beneficiaries will hold the power of direction, meaning that the one beneficiary would sign documents on behalf of everyone else. So you don't have to scramble around and find 10 signatures.
You know, Joe, the more you talk, the more I'm grateful that we have you in our corner.
Or confused. So one of the two.
You know, realtors are not supposed to look at legal documents and explain the legality of things to people. We can go over a contract in broad strokes, but we're really not allowed to discuss law, real estate law. And it helps to have you. What else you got for us, Joe? What else on your
this
radar?
I came across an interesting case. I'm not handling this case myself, but it was for a property in a western suburb of Chicago. And the people who bought the lot, it was a 37 and a half foot lot with a house existing on it. And the total lot was 75 feet. They received a loan, they closed, and they found out that in this municipality that only a 50-foot lot is permitted. And now they've bought this lot. They never received final approval for a lot division from the municipality. The seller has been paid. The seller owns the other portion of the lot. But now what do? You're involved in litigation. So having a realtor attorney who are somewhat competent, like me, for instance, I know the requirements of this particular town. So for me personally, it wouldn't have been an issue, but someone else, certainly coming across, if you're buying a smaller section of a bigger lot, there's a lot of questions you should raise. Is the lot divisible? Has a subdivision, plat of subdivision been recorded and approved by all involved? Is it worth a phone call to the municipality to make sure what you're buying is permissible? All of that could have been avoided before you spent, I don't know what the dollar amount is on the house, but it's probably a fairly expensive house. So that's an issue I just came across recently, and there's probably a laundry list of people here who maybe should have known better or been able to identify the issue.
I have a question, Joe. We've seen this happening a lot, especially lately with the market being so hot and the property selling so fast, where the sellers had no idea or have no, they put the house on the market without having a deep conversation with the realtors about where are they going after? Like, where are they moving after they sell the house? And most times, they have to find another house. And what happens if they can't find a house? Are they, some of them think that they can cancel the other contract last minute because they can't find a house. This is still my house and I'm not moving because I can't find another house to move to. What happens in that instance? Do they have to tell us what your experience with that is?
It's interesting. I think I've had actually maybe a couple with both of you where after you talk to them on the phone, the closing date is April 18th or whatever the date may be. And they think that if they don't have another place to live, they can continue living in the house. And at some level, I don't even understand that logic, but it does happen.
Mm-hmm.
And you have to explain to them you signed a valid and binding contract that on the closing date, unless there's a prior agreement, post-closing possession, you have to vacate the property in broom clean condition. And broom clean condition is also another, as I'm sure you've come across, another heated topic of debate, what that actually means. Are there holes in the wall? What furniture was remaining? And then you end up fighting over things in the final walkthrough, which maybe should have been removed, but the clients have already left town. There's always a laundry list of issues with that as well.
And then quickly, Joe, tell us what a post-closing possession agreement is.
A post-closing in the standard multi-board contract, there's a provision in there which could also be handled or modified by attorney review and attorney letters, but giving the seller an opportunity to stay in the property after closing, where typically you would pay the mortgage payment of the buyer, principal, interest, taxes, and insurance for a period of time until you leave. And during that time, also you continue paying utilities and maintain the house, and the same types of final walkthrough and issues when you tender the possession of the property to the buyer would occur as if you were tendering possession on the closing date.
All right. So we realtors sometimes refer to this as a rent back. So the property will close, but they let the seller stay for a certain amount of time. The seller pays all the expenses, the mortgage, principal and interest, taxes, utilities, etc. I'm not a fan of this.
Well, as a general rule, all attorneys dislike dealing with this as well, because we close and now we're still involved. We're holding the possession escrow, and in addition to the principal, interest, taxes, and insurance, the buyer is receiving from the seller, there's an amount of money held back to ensure that the buyer doesn't have a perpetual tenant in the seller to motivate them to leave. But we're involved after closing, dealing with all this, which no attorney really wants to do. They want to move on to the next deal as well.
Right. I always felt like there's a little risk on the buyer's part because
there's always risk on the buyer's part, because if they don't leave, if they damage the property and the damage is in excess of the amount you're holding in escrow, it's a problem.
Right. So I think, and Yvette, correct me if I'm wrong, a lot of times when we are in these scenarios, especially when we're representing the buyer and the house that our buyers are buying, that the sellers want to rent back, we do a lot of due diligence with the realtor and their clients. Like, right, we want to make sure we've done enough background check to see if these people would be what we would deem as risky or not risky,
to make
right?
sure they're going to be out when it's time to be out.
As a for instance, if you have a seller that is a hoarder and they have no place to live, where are they going to go? In their defense, where are they going to go? But they have to leave. So how do you handle something like that? Have you had instances where there's been hoarders where you've had to hire movers to help move them out and work with the closing date to make sure they were vacated the property?
I don't think we have had any hoarders. I mean, we remember we had a transaction not too long ago. I think it was last September, where the lady, she stayed after the buyer agreed to let her stay, and then she left the property in really poor condition. And sadly, the buyer's attorney didn't ask for, some money to be left behind in case this happened. And the client, I think the attorney had to pay for the cleaning of the place, because it was his bad that he didn't ask for, some kind of escrow to make sure that she was going to leave the property in good condition. And the property was left pretty nasty.
Another reason why attorneys don't want to be involved in
Right.
post-closing possession issues.
And guys, just so you understand how the process works, once the contract is signed by all parties, typically the communication then has to flow through attorneys. That's what makes it kind of binding. Yvette and I will always work through communication with the other realtor, but anything that represents a change in the contract really has to be done by the attorneys and signed off by all parties. So in Illinois, because we're in such a litigious state, you really do need a real estate attorney. I've only had a few deals where one of the parties didn't have an attorney, and what winds up happening there is the party that does have the attorney, they wind up doing double work, right? They have to explain everything to the people
Correct.
that don't have the attorney and say, you need to sign this document. This is what this document represents. It kind of sucks for the one attorney because he winds up doing double the work.
Right. And it's funny because there's a lot of areas in Illinois actually that they don't work with attorneys, usually in the far south.
Even Central Illinois.
Yeah,
there's some areas.
there is a lot of them that they don't, but I don't know how they manage that because there's a lot of things that I wouldn't want to have the attorney review them before we move forward.
Well, realtors there's in the Chicagoland area, I don't want to say realtors are spoiled, but many other states, realtors are handling the extension requests and other items that an attorney would typically handle, where realtors around here don't have that responsibility.
Well, Joe, we're spoiled because we have you. And, Yvette and I, we've been together since 2015, and we've had people in our office ask us, how many members of your team do you have? And it's only been Yvette and I. We don't have any admin people. We don't have anybody helping us. We are hands-on. We write up the contracts. But the reason why we succeed, is because we have people like Joe, where when we hand the contract off to Joe, we don't have to worry about it. We know it's in good hands. We don't have to supervise him. We don't have to supervise our lenders. We can do what we do best, and that's, cater to the client's needs. So kudos to you, Joe.
Yeah, well, I partner with people that are someone like me. I've been practicing for 27 years. I have a partner for 27 years. We don't have any other real staff. We outsource certain things that are out of our bailiwick, but generally our clients all have our cell phone numbers. I don't handle 1,500 real estate deals a year. I handle what I can handle personally and take care of myself. And so I don't have any miscommunications with my own staff. I handle all the deals. My clients talk to me personally.
Awesome. And the other thing out there for all you realtors watching this, and even folks who are home buyers and home sellers, Joe Hill represents kind of an oxymoron. He's an honest attorney, and he helps us out a lot, not just with our deals, but we have a lot of functions for our clients. He's always there. People love to see him after they've used him. He will do all of our deals for us unless one of our clients have their own attorney, and we still try and campaign to have Joe in the deal because he does a phenomenal job. Anything to add to that, Yvette?
No, I think you got it all, partner.
Joe, anything in closing?
I had a few other things to talk about. We can handle that in part 2 of our podcast, I suppose.
Awesome. Well, thank you for joining us today on the Velocity Real Estate Podcast. Again, kudos to our sponsoring broker, Keller Williams Preferred Realty. Thank you for joining us, and we'll see you on our next podcast.
Bye-bye.